Now, shall we begin the keynote session? In this session, we'll take time to hear the view of two chief judges and Wipo legal counsel on what make a good trial and what make a patent trial. Honorable Presiding Judge Hwansoo Kim of Seoul High Court will moderate this session. He previously served as a Chief Presiding Judge of Patent Court. Welcome back, Presiding Judge Kim. Please join me in welcoming him.
Good morning, everybody. Nice to meet you. As introduced, I am a former presiding judge of the Patent Court of Korea, and was the chair of the second and third conference organizing committees. I appreciate, therefore, personally, all the participants in this conference. This session is Chief Judge's session, and the theme is what makes a good trial and a fair patent trial. To spare the time, I'd like to introduce three speakers very briefly. For more information, you can refer to the reference book. First, Leonard Stark, Chief Judge, United States District Court for the District of Delaware. He has been a district judge since 2010. He began his legal career as a judicial law clerk to the Honorable Walter K. Stapleton of the U.S. Court of Appeals for the Third Circuit. Judge Stark is a graduate of University of Delaware, the University of Oxford, and Yale Law School. Okay. Next, Frits BONTEKOE, legal counsel of Wipo. Prior to joining Wipo, Mr. BONTEKOE was the head of legal affairs of the Office of the United Nations High Commissioner for Refugees in Geneva, and previously served for more than 12 years as a legal advisor in United Nations peacekeeping operations in Africa, Balkans, and the Middle East. Mr. BONTEKOE obtained his law degree from the University of Amsterdam. Lastly, Kyeong-ran Chief Judge, Patent Court of Korea. She has served as a Chief Judge of Patent Court of Korea since February 2018. She was first appointed as a judge to Seoul Central District Court in March 1985. She served as the Vice President of International Association of Women Judges in 2010. Now, three speakers will give their presentations in the order they were introduced. After that, I'm going to ask questions on behalf of the audience. First, Chief Judge Stark, please. Yeah.
Thank you. Thank you very much. It is a great privilege and a high honor to be here with you all today. I particularly took to heart the comments from the Justice just a few moments ago about the importance of friendship. It is just so rewarding to travel literally halfway across the planet and to come to a room full of friends who are interested in the same issues about fairness and rights in the patent system and intellectual property more generally that those on my court and in my country are dealing with on a daily basis. And I feel very gratified to be asked to give just some brief remarks on, from my perspective, what makes for a fair or good patent trial. And when I think of fair trials, what I have in mind is giving full and effective opportunities both for the intellectual property holder and for those who are accused of violating the intellectual property rights to be heard and to have their dispute resolved in a fair and possibly even a predictable manner. So 3 points that I'm going to focus on just briefly this morning that I think are a key to such a fair presentation and a fair trial. Strong advocacy, principally by the attorneys that are presenting the case. Effective pretrial case management, principally by the presiding officer, the judge that is, and an engaged fact finder. In our system, that is typically a jury, which is ordinary citizens drawn from a cross-section of our community, but at times can be, and in our court particularly often is, a bench trial, so the judge presides. So I will talk about each of those. But first, just real quickly, where am I coming from? You may be familiar with the American court system. Of course, we have 50 states, but we break that down into 94 districts, 94 trial courts across the country. And we are further divided into 12 circuits, courts of appeals that hear almost all types of cases based on the geographic origin of the trial, but notably our federal circuit hears all patent appeals regardless of where they come from. I would tell you that many Americans cannot find the state of Delaware on this map. It is the second tiniest state in terms of geography. To give you a little bit more of a clue as to where it is, we've done that to it. Even there, it's hard to see. We are not a very large state. But in terms of intellectual property, we do have a large impact because in the last few years, we've become the most popular court for filing patent infringement actions. Although we have only 4 judges like me on our court, 4 district judges, nearly a quarter of all patent cases were filed in the United States, that were filed in the United States, were filed in Delaware in recent years, which is just under 1,000 cases a year. So each of us gets about 250 new patent cases every year, which you would hope would give me something sensible to say about how to try a patent case. So here goes. Strong advocacy would be the first key to a fair trial. I really rely very, very heavily on the attorneys to help me be a good judge. I often say to the attorneys, I am only as good as a judge as you are as attorneys. What do I need from you as attorneys in order to ensure a fair trial? Obviously, you need to be very well prepared. You need to know the facts of your case. You need to know the legal burdens that you need to meet in order to prevail on your case. It's very helpful to have a story, a theme, a narrative to tie everything together and stay organized on how all the pieces of evidence fit into that theme that you have. Simplify the issues. Patent cases in particular inherently involve technical and complex subject matter, but really good attorneys are able, I've seen it done dozens of times, to take the most complex, novel technology, break it down into the simplest concepts that one needs to know in order to understand what the dispute is. And juries and judges can be taught to understand what they need to know. And be a good storyteller. Trials are ultimately about a story. How do things fit together? The fact finder is trying to find their way through difficult technology and hard law, and they're looking for someone who has high credibility that they can rely on to help them put the thing together, put all of the pieces together into a coherent whole. And if you are the lawyer in the room that can do that and that gives that confidence, then you are more likely to be successful. So that would be the first key in my view. The second key is effective pretrial case management. Sometimes I find there's a misunderstanding as to how the U.S. court system works. It is not as if you file a complaint alleging patent infringement on a Monday and by Friday you're in front of a jury of citizens trying your case. We have many months, typically up to 2 years of litigation before your case gets in front of a jury. And what we're doing during that couple of years is figuring out in various ways whether your case is one that actually merits getting all the way to the end of our system and to a trial. This burden mostly falls on the judge to help the parties carefully define what issues are worthy of a trial. We have all sorts of motion practice, requests to reduce the number of patents that are at issue, reduce the number of asserted claims that will be presented to the jury, reduce the number of prior art references that the defendant can ask the jury to consider in determining whether the patent was obvious or anticipated. Lots of motions practice, particularly summary judgment. after we have had time for each side to produce to one another in discovery all the evidence that they think is relevant to the case, the parties can file written briefs asking the judge to look at that evidence and assess whether it's the case that every reasonable person looking at that evidence would come to the same conclusion. If everybody reasonably would reach the same conclusion on that body of evidence, then we don't call a jury in. We just grant judgment in a summary fashion to the side who that evidence favors. Daubert motions, every patent case that I've done has a number of experts, technical experts, sometimes financial damages experts. Experts don't just get put in front of a jury without some careful vetting. It's up to me to decide whether or not what they are saying is something they are qualified to do and whether they have an opinion that fits the facts in a reliable manner. So we go through all of these steps, and if I'm doing my job well, that means that the only cases that end up in trial are those for which there is sufficient evidence on both sides, supported by proper expert opinion testimony, such that a reasonable fact finder could come out for either the patentee or the accused infringer. And that process is key to having a trial that is fair at the end. And then the third key, I believe, is an engaged fact finder, whether it is a jury or a judge that is ultimately finding what the facts are and deciding the case. It's important, of course, that the person who's making that decision be attentive. We do occasionally have some issues with jurors that fall asleep. We try to give them lots of coffee and chocolate, take frequent breaks, but obviously you need to pay attention in order to make these difficult decisions. We often find taking notes is helpful. When I sit as the finder of fact, which I do principally in pharmaceutical patent cases, I have my laptop usually in front of me and I just take notes throughout the trial. That helps me organize what's being said to me and keeps me awake and attentive. You need to obviously carefully evaluate who you think is telling you the truth, who is more credible, who puts together all the evidence in a fashion that makes sense to you. You have to keep an open mind throughout the entirety of the trial. Sometimes you'll be very surprised by evidence you hear towards the end of the case. It suddenly makes things you learned at the beginning of the case look very, very different. And finally, perseverance in demonstrating your willingness to work through what can be difficult issues. Again, you might think at the beginning, and this is typically true of my juries, they start out intimidated, thinking there's no way I, with no scientific background, can possibly decide whether this patent is infringed or invalid. We instruct them carefully. We tell them that many just like them have accomplished exactly this in the past. Just stick with it. The lawyers will do their job. They will present it to you. I will instruct you on the law, and you will be able to do it. So those are just 3 keys that I see to a fair patent trial. Thank you.
Thank you. Yes, it's very insightful and interesting presentation. And next, Mr. Frits, BONTEKOE, please.
Thank you, Presiding Judge Kim. Good morning, ladies and gentlemen. I was last in Korea in April last year on the occasion of the 20th anniversary of the Patents Court of Korea, and it's really a great pleasure to return to Daejeon and a great honor to be part of this distinguished panel. I'd like to thank the Patents Court of Korea and Chief Judge Cho for inviting me. We've been asked to discuss what makes a good and fair patent trial. And I would like to approach this question from a cross-border patent litigation perspective. I've also some slides to share with you. And let me see, yes. First, allow me to briefly introduce you to the work of the World Intellectual Property Organization, or Wipo. I believe that this will provide some context to my remarks. As many of you will know, Wipo is a specialized agency of the United Nations with 192 member states, and its main task is leading the development of a balanced and effective international intellectual property system. Wipo's origins date back to the 19th century, when the transport and industrial revolutions led to a desire for legal protection of intellectual work in cross-border settings. The 1883 Paris Convention for the Protection of Industrial Property and the 1886 Berne Convention for the Protection of Literary and Artistic Works, both administered by Wipo, were the result of this globalization in intellectual property. Now, in 2019, Wipo administers some 26 international treaties, and through the Patent Cooperation Treaty, the Madrid system, and the Hague system, facilitates cross-border prosecution of patents, trademarks, and designs, and also has a rich portfolio of technical assistance and international cooperation. This slide indicates the treaties that are administered by Wipo and the ratification status, in particular, by the Republic of Korea. And it shows that Korea is an active and prominent Wipo member state. I would like to state that the IP system is now under increasing stress from four main challenges. First, it is the rapid technological change that we are seeing. Second, the growing interdependence of the world's economies, cultures, and populations. Thirdly, the increasing and consequential role of IP. And finally, the multi-territorial nature of its exploitation. These developments are giving rise to novel questions. With legislatures, governments around the world lagging behind in making relevant policy, courts find themselves increasingly on the front line to provide clear answers to these questions. And I would like to focus on one of the challenges indicated here already on this slide, faced by the courts, namely addressing transnational disputes within territorial boundaries of IP rights and judicial structures. The fact is that ordinary market transactions now involve a host of entities and activities that cross borders. Value chains and distribution networks are permeated by cross-border movement of intangible capital, mentioned earlier by our colleagues this morning. Notably in the form of IP, protected technology and design and brands, but also literary works and artistic works. Disputes arising from these global value chains often involve foreign parties or IP right owners or activities and are left to domestic judicial resolution. This situation can lead to inconclusive outcomes. Current global litigation surrounding the so-called standard essential patents, or SEPs, demonstrates this phenomenon. SEPs, as you know, are patents that are implemented when a technical standard is used, notable in the manufacture and sale of products complying with global interoperability standards such as Wi-Fi and 3 and 4 and 5G wireless connectivity. The enforcement of SEPs licenses is currently one of the most stimulating and challenging topics in patent law. We will all be familiar with high-profile patent litigation involving important industry players in the telecommunications sector, such as Apple, Motorola, Samsung, Google, and Microsoft. Many of these patent disputes relate to what is called fair, reasonable, and non-discriminatory license terms, or FRAND. In these FRAND disputes, parties frequently try to use national court judgments over domestic patent rights to shape global business arrangements, with increasing extraterritorial effect of national judicial decisions. We're also seeing increasing use of the anti-suit injunctions, which is a procedural tool invoked by parties and employed by courts to enjoin parallel foreign proceedings in friend disputes. Indeed, we are seeing even anti-suit injunctions, which I hope to hear more about later today. This slide indicates further examples of parallel litigation procedures and anti-suit injunctions sought to stay international friend litigation in courts in Brazil, China, France, Germany, Japan, the United Kingdom, and the United States. These developments are described by some commentators as intra-jurisdictional competition or forum selling by courts. Judicial resolutions to this sort of litigation raise the risk of unpredictable outcomes for two main reasons. First, there is little consensus on according jurisdiction in transnational IP disputes. And second, there is equally little agreement on recognizing and enforcing foreign judgments on IP. The recently adopted Hague Convention on the Recognition and Enforcement of Foreign Judgments explicitly exclude, unfortunately, IP judgments. So these patent trials may be good and fair in their own individual and domestic context. However, whether that characterization also applies in the global cross-border context, which also corresponds to the business context, is an open question. The multiple parallel proceedings frequently result in unpredictable as well as unenforceable outcome with high costs. This in turn may also ultimately favor parties who have greater capacity to utilize courts in their patent strategies. Possible solutions include the establishment of a global court or arbitration tribunal, but these have their own challenges. Greater attention and dialogue by the judicial community will therefore be required to build good and fair trial solutions for cross-border patent disputes. Now, responding to these fast-evolving IP litigation realities and following growing demands from our member states, Wipo has adopted a systematic approach to international cooperation in the area of judicial administration of IP, which is led by the Wipo Judicial Institute. The Wipo Judicial Institute serves three main objectives. First, and that's on this slide, much has been achieved in the harmonization of substantive intellectual property law, but the same is not true of the judicial interpretation and application of IP laws. WIPO does not seek to harmonize the work of the world's judiciaries, but we do seek to facilitate judicial dialogue for informed and strengthened decision-making. The flagship WIPO event in this area is the annual WIPO Intellectual Property Judges Forum, and I saw the report and invitation for this year's forum is included in your bag. We held the inaugural forum last year, and it was attended by some 120 judges from 64 countries from around the globe. The discussions highlighted not only the similar challenges faced across jurisdictions with different legal systems, but also the distinct contrasts and variations. And as I mentioned, this year, the forum will take place at WIPO headquarters in Geneva from November 13 to 15, and we look forward to seeing a number of you again on that occasion. Second, WIPO supports member states in strengthening the human and institutional capacities of national judiciaries for both education and training. The first masterclass on IP adjudication was held in collaboration with the Supreme People's Court of China in August of last year. This year, it was hosted by the United States Court of Appeals for the Federal Circuit in Washington, D.C. The Judicial Institute also works with member states' judicial institutes to introduce IP programs in their regular continuing judicial education programs. WIPO's work in this area is defined strictly by the needs, priorities, and distinct legal context of each member state. We emphasize the sustainability through the incorporation of a train-the-trainers model and the use of modern multidisciplinary, and participatory training approaches. In total, in 2018, the broad range of Wipo's judicial capacity building activities reached over 220 judges from 48 countries through 20 separate events. Third, Wipo also works to advance collective international knowledge about the state of judicial administration of IP by making available, with the cooperation of national courts, leading IP judgments from different jurisdictions. We are currently running a pilot project to build a database that will provide easy online access to IP judgments. And soon, and we hope in November of this year, the initiative will expand to jurisdictions from all over the world. The aim is to build a specialized one-stop, free of charge, public online database for curated leading IP judgments. In addition, the Judicial Institute has engaged actively with its global interlocutors on IP publications related to the judiciary. A long-standing collaboration between Wipo and the Hague Conference on Private International Law has led to the publication of a booklet called When Private International Law Meets Intellectual Property Law, a guide for judges. In the coming month, the Wipo Judicial Institute will launch the first volume of the collection of leading judgments on intellectual property containing recent judgments from the People's Republic of China. Each further installment of this new series will promote greater global access to the jurisprudence of a chosen jurisdiction. And just quickly, as you can see from this slide, the Judicial Institute works closely with judiciaries from around the world for the effective delivery of its services to create a space for dialogue, to deliver capacity building activities, and to increase the availability of information about IP and courts. In concluding, let me just say that we are extremely grateful for the support of the Patent Court of Korea, one of our first partners in these endeavors. We look forward to building on this relationship to promote rigorous exchange of views and judicial minds on IP questions through conferences such as this one, and continuing our deliberations to safeguard good and fair patent trials, both in a national and a cross-border setting. Thank you for your attention.
Thank you so much, Mr. BONTEKOE. Very interesting. The forum selling course and the IP Judge Forum is especially very interesting. Okay, thank you. Next, lastly, Chief Judge Kyeong-ran.
Ladies and gentlemen, I'm Kyeong-ran. In this session, I'm here to talk about what makes a good trial and a fair patent trial. I have someone's timetable here with me. I can see that he's a morning person since he's getting up at 6 o'clock every day. He seems to take good care of himself as he exercises every day before and after 8 hours of work. Another thing that stands out may be that he spends 1 hour to work on his elocution and poise every evening. But to me, the most impressive part about this timetable is that he spends 2 hours to study inventions every night. Any ideas whose timetable this is? Well, it belongs to J. Gatsby of The Great Gatsby by F. Scott Fitzgerald. As you know, Gatsby came from a humble background, but tenaciously committed himself to becoming rich and successful when his love, Daisy, had married a wealthy man. And it is very telling that a character like Gatsby, whose eyes were fixed on the goal of success, was described as devoting 2 hours on invention every day. The book was written a century ago, but achieving as an inventor was already seen as a good way to climb up the social ladder and make a great fortune. And I believe this was because patent rights had been duly protected and enforced by good and fair trial. Let me share what I think is a good trial from my own experience. I did not always want to be a judge. In fact, I wanted to be a musician when I was young. The three girls in the picture on the screen are my middle school friends and I. I'm the one at the far right. It was a Bible verse that I came across when I was in high school that made me dream about becoming a judge. So, give your servant a discerning heart to govern your people and to distinguish between right and wrong. For who is able to govern this great people of yours? 1 Kings chapter 3, verse 9. The wise judgment King Solomon made on the two women disputing over one baby made me want to be a wise judge who can distinguish between good and evil, one who can discern truth from falsehood. Thankfully, my dream came true. And in the early years as a judge, what I valued the most was finding the substantive truth. At the time, surrounded by stacks of case files, I went through them over and over and over again until I felt comfortable that I got everything figured out. I believe that thorough examination of case records ought make me a competent fact finder, and that if I'm good with facts, sound legal judgment would follow naturally. Yet several years ago, I read a Bible verse that gave me the dream of wearing the robe in English. In that version of the Bible, the discerning heart was written as the understanding heart. And today, the judge I want to be is one who not only finds substantive truth based on thorough review of the case files, but also one who really listens to the voice of the parties and has the heart to understand them. So that's my idea of a good trial. Then what makes a fair patent trial? I think what we need the most is precise review of the case. And precise review is enabled by sufficient evidence collection, utilizing orders to submit documents or materials. Making changes to the way the courts look at inventive step and other issues is also something we can do. Not only must justice be done, it must also be seen to be done, as put by Lord Chief Justice Hewart of England. Justice is seen to be done in patent litigation by involving the parties in the fact-finding process. In this light, the Patent Code of Korea provides the inventor an opportunity to explain the invention. Also, the International Division of the Court allows oral arguments in a foreign language to accommodate foreign parties who take up about 30% of our total cases. Meanwhile, it is critical that such precise review is carried out in a prompt manner. As technological development accelerates, technology life cycle is shortening. Therefore, due protection of a rightful patentee mandates prompt trials. The average time for the Patent Code of Korea to handle a case is about 5 to 7 months. What I have discussed so far is actually applicable to all lawsuits in general. Now, returning to patent litigation, what makes a fair patent trial? My answer is specialized courts and specialized judges. The Patent Code of Korea is the first IP specialized court in Asia, and it prides itself as the juncture where law and technology cross paths. For specialized examination on technical issues, the Patent Code of Korea has 23 technical examiners and 107 technical advisors. In addition, to expand its research capacity and promote efficient academic exchanges at home and abroad, we have our own research center, the International IP Law Research Center. We also put effort to ensure the judges' expertise. Our judges have backgrounds in intellectual property and more than 10 years of experience on the bench. Further, they continue to engage in research in various IP-related subjects through research committees. As I sum up, I want to emphasize the importance of international cooperation. We have seen a surge in registration of the same intellectual property across the world. And we often hear about global patent wars from the media. A good example would be Apple versus Samsung, with about 50 lawsuits worldwide. In today's world, cooperation among IP judges is no longer optional. This conference, first launched in 2015 to promote exchanges among IP judges, celebrates its 5th anniversary this year. The Patent Code of Korea is not alone in its effort. Many courts and many countries have joined hands toward this goal. And I'm certain that Wipo will continue to play a crucial role along the way. Now, let's pause and think for a moment. What if treasured meetings like this would not just take place once or twice, but all around the year? What if we have somewhere we can communicate on any regular day, from casual greetings to detailed discussion, where we can also share materials from the conferences we just saw? Wouldn't that make our cooperation more advanced? For this reason, I dream of an online space for IP judges. So I propose the ipbench.org, a small website for us. As you see, the IP Bench is a very simple website. But if judges sometimes post their decisions here or to introduce new systems of their countries, wouldn't that help to resolve IP disputes in more suitable and harmonized ways? And sometimes you can share folders and snapshots of fond memories like this on the IP Bench. Or you can send messages to other judges for quick questions. If we continue our communication even through this simple website, and if we carry on with these efforts, wouldn't we still see, 100 years from now, a young man trying to reach for the stars, studying invention every night? Thank you.
Thank you so much. All the presentations are completed, but the time almost passed. But now I'd like to ask questions to the speakers. First, just Chief Judge Leonard Stark. In the United States, after the Supreme Court T.C. Heartland decision in 2017, there must have been a big change in the number of IP cases among district courts. Can you tell us about the changes you have observed so far? Yeah.
Yes, thank you. So in the last 2 years, the number of... Hold that.
Okay.
Can you hear me? Okay. Since the TC Heartland decision, the District of Delaware, which had always been, at least for recent decades, usually the first or second busiest patent court in the country, became the #1 busiest court. We've seen roughly an 85% increase in the number of patent cases filed in our district in the last 2 years. The largest percentage of that increase appears to be cases filed by non-practicing entities. Some of those cases settle fairly quickly, but we do see an increase also in competitor-to-competitor cases, and we've seen an increase of about 15% in the pharmaceutical patent cases, which go to trial at a much higher rate than the non-pharmaceutical cases. So we've been a busy court, and we've become even busier in the last 2 years as a result of the TC Heartland decision.
Thank you. The burden of each judge is getting heavier every year.
That has been the trend so far, yes.
Okay. Next to Frits BONTEKOE, I admire the remarkable activities carried out by Wipo and you. Regarding the great work of yours, I think that developed and developing countries would often have disagreements in the course of drafting treaties. What's the role of Wipo, and what is your role to achieve an agreement between them?
Thank you, Judge Kim. I think one of the main roles of WIPO is obviously to provide a forum for its 192 member states, as I mentioned earlier, to agree on international norm setting. And the 26 treaties that we are administering, I think, is the positive result of that role. But when you mention the difficulties with respect to agreements, indeed, it is not always easy to reach agreement. But it's not necessarily difficulties or differences and disagreements between developing countries and developed countries. There are likewise disagreements and differences among developing countries and developed countries. Let's take the example of exhaustion, which I know is also going to be discussed later today. The US Supreme Court has decided in favor of international exhaustion. On the other hand, the EU applies a regional exhaustion where rights are exhausted solely within the EU market. So the principle of exhaustion, as an example, is something that is applied by most states and in furtherance of their public policy objectives. But the disagreements that exist among them reflect more a socio-economic and cultural realities that applies to these countries, and I think it's important that that is being acknowledged. But yes, WIPO does, of course, provide a platform for international norm setting with respect to subjects that have reached certain maturity and a multilateral consensus. Now, one more comment. It's also important to recognize that reaching agreement is not necessarily the ultimate goal. Where consensus is lacking, there is still an important role to play in bringing member states together to exchange views on their differences and to build bridges through dialogue. A good example for that is we just a couple of weeks ago organized so-called conversation on intellectual property and artificial intelligence, where member states came together to indeed exchange views on issues relating to artificial intelligence, not to reach agreement, but rather to define and articulate questions, the right questions, that would help them in addressing issues relating to the impact of artificial intelligence on the international IP system. So I hope that clarifies it a bit. Thank you.
Thank you. Lastly, to Chief Judge Cho, you introduced a playground for IP judges with an cute character, a website made by the Patent Court of Korea. Is it your opinion that the website can help to establish a bond of unity among the IP judges around the world?
Yes, it is. Thank you for the great question. We have a closed website just for patent court judges. The judges use this website when they come up with the question while working on patent or trademark cases, and they can share even the slightest question they may have. And anyone who has something to say about it can post a short comment to the question as soon as they see it. Such exchange of views naturally leads to precise review and good trials. It got me to thinking that we should have something like that, not just within the patent court, for all the judges around the world who handle intellectual property cases. I hope that we can continue our valuable discussion here on the IP Bench website, and in turn, form persistent and long-lasting friendship Justice Jung-hwa Park spoke of. And I think that would lead to more meaningful discussion and practical protection of intellectual property rights. Thank you.
Thank you. Thank you for all the answers. I'm sure that you want to hear more from the speakers, but I am really sorry that we have just short time and the keynote session must be wrapped up now. Please give a big hand to these brilliant speakers. And thank you so much to all the audience for your attention. Thank you.
Thank you, everyone. This ends keynote session. We'll begin session 1 at 11:20 a.m. after short break. I would like to ask moderator and speakers of session 1 to come to stage before that time.